My name is Milla Pennanen, and I'm working as an executive director in Makers of Finland. And today I'm going to speak to you really quickly about really important thing, which is about knowing your rights. I have many slides, but I will skip and go really fast them. But first, shortly about Makers of Finland. And Makers of Finland is a proper union which was founded almost 3 years ago. And our mission is to help and support the game industry and help to build best practices for this industry. And one of our best practice thing is to teach you about the rights that you employees have. And then the Finnish game industry is growing all the time. And now we have over 3,000 people working in this field, and almost 30% of them are from abroad, and that amount is rising every year. So we have to network and create together the best practices so we can keep the industry safe and healthy. But now let's go to the things. So one of the rights and really important things is the salary. And we made this salary survey 2 years ago, and we're going to make it again, and we're starting it in November. But here are a few facts about the salary survey. And the kind of the main normal person in game industry is a 35-year-old male who has bachelor's degree and is working in the capital area, and the median salary for that is 3,700 euros. So it's the median, and the salary varies a lot, as you can see in the lowest and highest options there. And when you get the salary, you should always check and read through the paycheck. And we made this clear instructions about the paycheck and all the terms that there is. So it's really important that you always read it through. And yeah, so let's move to the next one. And it's about the work contracts or the employment agreements. So when you start working in a gaming company, we highly recommend that you have a written contract, because it means that everything is written down. So if you have any issues coming, you can check the details from there. And contracts can be many different models. Open-end. I saw the question there about the salary. Those numbers, they are before taxes, and yeah, they are before taxes. And yeah, you can actually, I forgot to say that you can download the slides from our booth. They are there in the handouts. You can download, and then you can read them through, and yeah, keep them safe. But yeah, about the models of the work contracts, open-ended means that there is no end until you end of your work contract, but then there is fixed term contract, but you can have a fixed term contract only for a justified reason. And here in the slides, there are listed few of those reasons. But then when you have the work contract, there should be few things listed. And here are the principal terms that you should have there. And if you have the contract already, please see it through that you have all these things there. If you don't have, you can ask and negotiate with your boss, and please ask them to add these things there. And we made this work contract, like the basic work contract, you can use and check, and it's in our website. You can download it there. And yeah, the few of those important things in the contract is, for example, the working hours and where the work is done. So the place of the work is really important nowadays. And then moving on. So when you start to work, you may have the trial period, and it's the maximum of 6 months. and it starts from the day when you start working there. But if you have a fixed term contract, which is shorter than 12 months, it can be maximum of 50% of the duration. For example, if you have the contract for 10 months, then the trial period can be only for 5 months. Which, yeah, I hope that you have it like that, and if you don't, you should talk about that in your company. And of course, if you have any further questions about these things and you don't have personal representative at your work, you can contact the union, for example, us. And if you have any questions, you can ask those questions through the chat. And I try to read it and answer those things. And then the next topic is, well, this is the sad one. So termination of the work contract. Here is the one thing I want to point out, and it is the period of notice. So it varies from 2 weeks to 6 months, and there could be more info about that in your work contract. So there might be something else that you have agreed on, but this 2 weeks to 6 months is based on the law. And it means that if you have worked less than 1 year and the employer terminates your work contract, then it's the 2 weeks. And if you have been working there from 1 to 4 years, then it's 1 month, and it grows like that. And if you've been working there over 12 years, then it's 6 months. But if you decide to resign yourself, then it's 2 weeks if you have been working there for a maximum of 5 years, and over 5 years, then it's 1 month. But there could be some other figures in your work contract, or if you have some other contracts, so you should check those things there. And then is the cancellation of the employment contract. It can happen only with a really extremely weighty reason or cause, and it has an immediate effect. So there is no notice time, and there is a compensation if the cancellation is groundless, and that means that the employee should have really good compensation, minimum of 3 months salary. So if you happen to have this kind of situation, you should ask more help or opinion from the union, because these things might happen and they are always really, well, not nice situations. And then this one really important point is also prohibition of discrimination. So if you suspect or if this happens to you, or you suspect that this happens to someone else at your workplace, or you are discriminated, it means that you have to immediately contact your union or a personal representative, because this is against the law. Discrimination is against the law, and here are listed all those reasons and things that are under this discrimination law. And then non-competition agreements. It also, we have these agreements, and then copyright agreements and IP rights. So before you sign this kind of agreement, or well, work agreement, you should always ask someone else to help you, usually the union. This is one of the things, the most wanted service from us, that we check the agreements. And if you have the non-competition agreement, it has a maximum of 6 months, and more than 6 months is highly unrecommendable, but it could be for maximum of 1 month if there is a proper compensation for that. But it's quite common in game industry, but remember these limits there.